Starting in 5 seconds. There is someone who said truth is learning from facts, and I am grateful to my colleagues for giving me this opportunity to know firsthand what are the inadequacies, what are these challenges that police services face in our country in discharging their wondrous duties. I have listened with great respect to the presentations that have been made, and I do feel that the time has come when we should be integrating policing also into our planning for development purposes. This old fashioned division between the development expenditure and non development expenditure has outlived its utility, and I will go back and discuss with the Planning Commission with the Home Ministry how best we can develop our so called development and the so called non development sectors of our economy. I do feel, listening to the presentations that have been made, that there is an urgent need to look into the future, what type of police system our country needs in grappling with the challenges that are now on the horizon, and where we are, how much distance we have to travel in order to ensure that we provide our country a police system which is adequate to the challenges that our country faces. So, this is one thing which I would say we have in our systems 5-year planning for the defense forces. I would suggest to the Honorable Home Minister that maybe time has come we should form a 5-year or maybe a longer term perspective plan which would take into account the imperative need for upgrading our technology, our human resource strategies, and all the other related subjects which have been discussed. In particular, I was very fascinated by a suggestion that in certain insurgency affected areas, police should be involved in development work. I am reminded by what my esteemed friend, who was at one time Cabinet Secretary in the Government of India and the Chief Secretary of Orissa, he told me about the link between the police system and the development works. He said to me that as Chief Secretary, he once received a number of senior police officers, and the police officers said that the general perception the public about the police is not very good. We want to do something which would change that perception, and so he suggested for the policeman involvement in public works. One thing that I do wish to say is that 80% of the police personnel belong to the category of constables, and I think this is certainly true that we have not paid adequate attention to ensure that the constables of the future are being produced by our policing system. Some years ago, I was told in Maharashtra that 75% of policemen live in chawls in slum areas where they interact all the time with criminal elements. Now, out of that policing system, you cannot produce men and women of integrity. I think there are lot of temptations to fall off the chosen path of goodness. So, we have to pay a lot more attention to ensuring that we provide adequate facilities for our constable housing facilities. Certainly have to improve, but also training their psychological mental makeup, and this also applies to many police schools also. The constitutional values of our republic, respect for diversity, respect for inclusiveness, and a deep and abiding commitment to secular values that people belonging to all faiths have an equal claim to the protection of law and of the state. These are some of the other issues which I believe ought to receive a lot more attention as we plan for the future. Therefore, I am very happy to be here today to participate in this interaction with you. I have learned a great deal. I hope that the Home Ministry will follow up on the suggestions that have been made, find out a list of urgent areas where there is need for immediate action, also devise a strategy where we can act, maybe not immediately but over a period of time, a medium and a long term strategy, giving our country a police system which is equal to the challenges that our country faces. I have had this chance to sit through the presentations. It is heartening for me to note that, in spite of the rigors of your daily routine, you have all retained the analytical abilities to understand the problems that lie at the core of your work and come up with possible solutions to improve police administrations at the grassroots. The ability to analyze and resolve issues in a turbulent and changing world, keeping in view the larger national interest, is the fundamental reason why this country needs an all India service like yours. You have been charged with the wondrous responsibility of maintaining law and order and in ensuring peace and security across the length and breadth of our country. Law and order is fundamental to the existence of a functioning democracy and a civilized society in the country. Stop. Starting in 5 seconds. Mr. Speaker, sir, some of us who have the privilege of being in this house for the last 50 years have gone through 50 budgets. I feel that this budget viewing from all angles is really a budget which this country needed at this hour when there is widespread inflation all over the world and every country is struggling to reduce it, and also when there was almost a shadow of recession in this country and there was a heavy rainfall which led to good crop and agriculture produce prices were going down. At this juncture, a budget with maximum investment, minimum taxation, and less deficit as compared to the past few years is a budget that is really a powerful fillip to economic growth, savings, and more investment both in industry and agriculture. This is the type of budget that perhaps the opposition people never expected. There is some criticism here and there about taxation and excise duties, as the finance minister has mentioned clearly. The reduction in excise duties in the case of a few industries is not only to help the middle class people who use TV sets, batteries, or cares, cars, but also the industries and the employees working in those industries. If there had been a layoff in the Hindustan Motors, for example, the honorable member would have been the first to organize labor and come to the finance minister to take measures to have them taken back in the factory. So that way, the finance minister has reduced the excise duties on certain items. It benefits not only the class of people who use those products, it also helps to keep those industries manufacturing those items, avoid layoffs. There are hundreds of thousands of industries units in this country making these things. As regards the reduction in income tax and wealth tax, it is said that it stimulates disclosures of more hidden wealth. I am sure the finance minister would succeed, and then we shall certainly compliment him. More than anything else, the largest investment this year in the plan is judicially distributed on priority subjects. The maximum amount has perhaps gone to priority subjects like agriculture, irrigation, and power. Even such subjects like social welfare, which were starved for the last 3 years, are not neglected. In this judicious distribution of the budgetary allocations regarding investment in the plan, the government has done well. One fact which I want to bring to the notice of the Honorable Minister is a pitiable condition of the farmers today, the agriculturists who are the backbone of this country, who still form 70% of the population and who produce 50% of the national wealth. Whenever the authorities wanted to hold the price line, the victims have always been the farmers. If the price line is horizontal or vertical, you could hold it, but it has always been a curved line. So the victims have always been the farmers. In the emergency situation, rains also started. There were unexpected heavy rains all over the country. I have been associated with agriculture since the last 25 years as deputy minister here and later as a minister in my state. I have never seen a good year as far as rainfall is concerned as last year. It was a year which might not repeat itself. There was no scarcity of rain at all in any part of India. It was only excess rain here and there which has spoiled the crops because of floods everywhere. Of all the experienced people in agriculture, the finance minister has got a very good background in agriculture. The finance minister has got a very good background in agriculture. When he was in charge of food and agriculture ministry, he had introduced the hybrid seeds and he gave a fillip to the use of technological know-how in agriculture. I thought he would have certainly understood the farmer's plight and he would have brought forward much more relief to the suffering farmers of today. But that has not been done. In the agriculture line, out of a cycle of 5 years, it is said 1 year will be good, 1 year will be bad. One year will be neither good nor bad, and 2 years are indifferent. So, in a cycle of 5 years, there will be one good year only. When the farmer gets good crops during that period of 1 year, he suffers. What are the prices of cotton, oilseeds, food grains, etc. today? Those were the years when the prices of these agricultural commodities had increased more than 100%. I can give you the prices of certain agricultural products that are sold today. That is the position obtaining in oilseeds and various other commercial commodities also. When the prices have come down, the farmers have no money to buy other essential commodities, and this is the state of affairs from the beginning. Planning Commission has also been advising the states to tax the rural sector. They thought that there were rich people in the rural areas and they should be taxed. Stop. Starting in 5 seconds. Madam Speaker, to promote the Make in India initiative, we have undertaken rationalization of customs duties and procedures. Our government has abolished duties on 36 capital goods. A revised system of importing duty-free capital goods and inputs for manufacture and export has been introduced, along with the introduction of single point of approval under section 65 of the Customs Act. Indian Customs is introducing full and comprehensive digitalization of export import transactions and leveraging RFID technology to improve export logistics. Our government is committed to eliminating the ills of black money from our country. The anti black money measures taken by us during the last 4.5 years in the form of black money law, the Fugitive Criminal Offenders Act, and demonetization have brought undisclosed income of about rupees 130,000 crore to tax, led to seizure and attachment of assets worth approximately rupees 50,000 crore, and compelled holders of large cash currency to disclose their source of earnings. During this period, Benami assets worth rupees 6900 crores and foreign assets worth rupees 1600 crore have been attached. As many as over 3 lakh shell companies have been detached and deregistered and their directors disqualified. Growth of 18% in direct tax collection in 2017-18 and increase in tax base by as many as 1.6 crore people filing income tax returns for the first time in 2017-18 is mainly on account of demonetization. Madam Speaker, the NDA government, headed by Honorable Prime Minister, has laid the foundation for India's growth and development for times to come. We have resolved many problems which we were coming in the way of realizing our full potential as a society and an economy. We are poised to become a $5 trillion economy in the next 5 years and aspire to become a $10 trillion economy in the next 8 years thereafter. In the Indian ethos, anything which is good is supposed to bestow, cause, create, and do good in all 10 directions. I will therefore lay out our vision for 10 most important dimensions in 2030. The first dimension of this vision will be to build physical as well as social infrastructure for a $10 trillion economy and to provide ease of living. It will comprise next generation infrastructure of roads, etc. The second dimension of our vision is to create a digital India reaching every sector of the economy, every corner of the country, and impacting the life of all Indians. Digital infrastructure and digital economy of 2030 will be built upon the successes achieved in recent years in digitization of government processes and private transactions. Our youth will lead us in this endeavor with innumerable startups creating digital India and millions of jobs in this ecosystem, making India a pollution free nation with green mother earth and blue skies is the third dimension of our vision. This India will drive on electric vehicles with renewables becoming a major source of energy supply. India will lead the world in the transport revolution through electric vehicles and energy storage devices, bringing down import dependence and ensuring energy security for our people. Expanding rural industrialization using modern digital technologies to generate massive employment is the fourth dimension of our vision. This will be built upon the Make in India approach to develop grassroots level clusters, structures, and mechanisms encompassing the MSMEs, village industries, and startups spread in every nook and corner of the country. India is now on the way to becoming a global manufacturing hub in various sectors, including automobiles and electronics, defense and medical devices. Our rivers and water bodies are our life supporting assets. Our government has worked vigorously for cleaning River Ganga. Fifth dimension of our vision for India of 2030 is clean rivers with safe drinking water to all Indians, sustaining and nourishing life and efficient use of water in irrigation using micro irrigation techniques. India's long coastline has the potential of becoming the strength of the economy, particularly though through exploitation of the blue economy to ensure better standards and quality of life for a large number of people living in the coastal areas. Our efforts in the Sagarmal program will be scaled up and we will develop other inland waterways faster. Our coastline and our ocean waters powering India's development and growth is the sixth dimension of our vision. The seventh dimension of our vision aims at the outer skies. Our space program Gaganyaan India becoming the launchpad of satellites for the world and placing an Indian astronaut into space by 2022 reflect this dimension of our vision, making India self-sufficient in food, exporting to the world to meet their food needs and producing food in the most organic way is the eighth dimension of our vision. High farm production and productivity will be achieved through focused attention. Stop. Starting in 5 seconds. Sir, I come to the second amendment bill. Here, the Honorable Minister wants to make an improvement. I very well understand it, and to some extent it is welcome. He wants to cover an employee who has interrupted service and that interruption in service being created as result of his absence without leaving from service. The amendment bill proposes to include this interrupted period of service of such an employee within the meaning of continuing service for the purpose of payment of gratuity. This much I welcome. But I would like to point out to the Honorable Minister that regarding 240 working days, the ambiguity is still there and the day may not be far off when the Supreme Court may interpret in it another way and you may have to come with another amending bill before the House. So that ambiguity should have been cleared by you. Here again, I beg to submit the Honorable Minister makes a provision which is entirely detrimental to the interests of the worker working in the factory or in some other establishment. Sir, I would like to draw the attention of Honorable Minister. Of course, he knows everything what is contained in the bill. That on page 2 of Payment of Gratuity Amendment Bill 1984, it says not being absence in respect of which an order imposing an punishment or penalty or treating the absence as break in service has been passed in accordance with the standing orders, rules or regulation, etc. Here again, an unscrupulous employer, the number of whom is not small in our country, of course, may take advantage of this provision and for some reason or other, even on flimsy or false grounds, may impose a break in service of an employee every 4 years and thereby deprive the employee of his legitimate claim of gratuity. So, this provision should not have been there, and I would submit to the Honorable Minister that the entire stipulations within bracket in this section 2A should be deleted for the workers working in factories if we want to do something better for the workers working in the factories and some other establishments. Madam, I would like to submit that the Payment of Gratuity Act is now about a decade, more than a decade old, and this act seeks to provide a tiny dose of social security to working population. Further, I would like to draw the attention of the Honorable Minister to the fact that the working of this act, the experience of the working of this act, the Payment of Gratuity Act 1972 for the last 12 years has not been too much success. There are certain drawbacks, flaws and lacunae in the Payment of Gratuity Act 1972, and with these drawbacks and flaws, the act is becoming less meaningful to the workers for whom this act is meant. I would like to mention just a few of them. There is a provision that a worker is entitled to get gratuity only after he has completed 5 years of service. Why should there be this limitation of 5 years. Let us take an example. Let us say a worker becomes disabled after 3 years of service. What will be his position? The demand of the working people is that such as person should be paid gratuity for the period of service rendered by him, so that with this gratuity amount he may be able to sustain himself for some days or for months or two. You should, I submit, at best to bring down this period of limitation to 1 year of service, because 1 year's duration of service is, I think, quite sufficient to access or gauge the performance of a worker or employee working in a particular establishment. Then again, madam, there is another drawback which lies in the Principal Act, namely the Payment of Gratuity Act 1972. That is, the gratuity amount of a worker is not adequately protected. Therefore, I would suggest that such a statutory measure should be brought forward by the government, which will enable the gratuity money to be adequately protected. There has been a constant demand from different sections of the workers that a gratuity fund should be created like the Provident Fund, with this difference that in the gratuity fund only the employer will be required to deposit his portion of the money. This fund should be kept quite apart by the employer for the payment of gratuity, and under no circumstances the employer shall be allowed to use the gratuity money for his own purpose. Such an arrangement should have been made in the Gratuity Act. Now, there is another thing, madam, which I would like to point out. Under the present provision, an employee is entitled to gratuity if he works or serves in an establishment which has at least 10 employees, initially at least. You have made an amendment that initially it should be 10. That is not a fair. Stop. Starting in 5 seconds. Sir, it had been further argued on behalf of the defendants that under Section 34 of the Specific Relief Act, the plaintiffs must have a direct interest and entitlement over the property for which the declaration is sought. Section 34 of the Specific Relief Act states discretion of court as to declaration of status or right. Any person entitled to any legal character or to any right as to any property may institute a suit against any person denying or interested to deny his title to such character or right, and the court may in its discretion make therein a declaration that he is so entitled, and the plaintiff need not in such suit ask for any further relief, provided that no court shall make any such declaration where the plaintiff being able to seek further relief than a mere declaration of title omits to do so. In the present case, the plaintiffs are not seeking a declaration that they have a beneficial interest. A derivative action is sought only for the beneficial interest of the second defendant. The second defendant has, however, abjured such interest. Whether such disclaimer or abjuration is the result or effect of collusion or fraud are further aspects to be examined. Such abjuration has to be weighed with the flow of funds through the second defendant to the first defendant, leading to the allotment of shares to the third to the seventh defendants. Examining all these aspects can only be through advancing oral and documentary evidence. This would further imply that the suit has to be retained on file. It had been further contended that the suit relief is barred under Section 187C of the Companies Act 1956. It had been contended that primarily the third, fourth, and seventh defendants should first make a declaration that though the shares are in their names, a beneficial interest had accrued to the second defendant. Similarly, the second defendant has to make a declaration that they are the beneficial interest holders of the said shares. It has been contended that in the absence of the above declarations, seeking a declaration against the first defendant would be akin to putting the cart before the horse. I hold that the declarations made or not made in the books of the first defendant would be to the exclusive knowledge of others. In this context, the 8th to 10th defendants have a vital role to play. Evidence is necessary from their end to disclose facts and to subject themselves to cross examination on all these aspects. The plaintiffs have pleaded the facts to their knowledge. It must also be kept in mind that except the third defendant, no other defendant had sworn to an affidavit. Questions raised by the plaintiffs remain unanswered, and trial is also the answer to determine the actual facts. I hold the plaintiffs cannot be non-suited at the threshold. The suit is only at its early stage. It still has a rough course to clear. The reliefs sought may be superfluous, but if the plaintiff discloses a cause of action and if the plaintiffs are prepared to battle out the issues at the time of recording the evidence, then again they must be afforded such opportunity. At this stage, the plaintiffs have come to court primarily claiming a declaration as against the first defendant. Whether the third, fourth, and seventh defendants on the one hand and the second defendant on the other hand have made declarations in accordance with the provisions of either Section 187C or Section 89 of the Companies Act 1956 or 2013 are facts to the exclusive knowledge of the fact second, third, fourth, and seventh defendants and also the eighth defendant. The plaintiffs could never have had access to the records of the first defendant. The queries raised in the pre-suit notice have not been answered. Consequently, they have sought a declaration only against the first defendant. This declaration is sought because in Dubai, the third, fourth, and seventh defendants had made similar declarations, and in the plaintiffs have stated that they believed that similar declarations had been made in the books of the first defendant. This statement of the plaintiffs has to be tested further through oral and documentary evidence. Consequently, I am not in agreement with this contention raised by the defendants. Trial is the answer to settle facts. At this stage, the plaint averments hold the sway, and a reading makes it obvious that the first defendant has to open up its records for scrutiny, and that can be done only during trial. To sum up, the allegations raised in the plaint have to be examined at Chennai, since the first defendant is registered in Chennai during its pre-incorporation, incorporation, and post-incorporation stages. Substantial amounts of money had flowed to it. It is only with examination of the books of the first defendant that the source of the funds can be determined. Stop. Starting in 5 seconds. Personal liberty of a person is one of the oldest concepts to be purported by national courts. As long ago as in 1215, the English Magna Carta provided that signature not verified, no free man shall be taken or imprisoned but by law of the land. Today, the concept of personal liberty has received a far more expensive interpretation. The notion that is accepted today is that liberty encompasses these rights. That is accepted today is that liberty encompasses these rights and privileges which have long been recognized as being essential to the orderly pursuit of happiness by a free man, and not merely freedom from bodily restraint. There can be no doubt in saying that lodging juveniles in adult prisons amount to deprivation of their personal liberty on multiple aspects. This writ application under Article 32 of the Constitution is at the instance of a convict accused undergoing life imprisonment for the offense of murder, seeking appropriate directions to the respondent state of Uttar Pradesh to verify the exact age of the convict on the date of the commission of the offense, as it is the case of the convict that on the date of the commission of the offense, that is 10th September 1982, He was a juvenile aged around 15 years. The facts giving rise to this litigation may be summarized as the writ applicant, along with other co-accused persons, was put to trial for the offence punishable under Section 302 under 34 of the IPC. Secondly, the fifth additional sessions judge Agra in the sessions trial arising from the case crime number 126 of 1982 registered with the Fatehpur Sikri district, Agra, held the writ applicant herein and the co-accused persons guilty of the offence of murder and sentenced them to life imprisonment. Thirdly, the writ applicant herein and the other convicts went in appeal before the Allahabad High Court by filing the credit appeal questioning the legality and validity of the judgment and order of conviction passed by the trial court in 1986. Fourthly, the appeal was heard by the High Court and with judgment and order came to be dismissed, thereby affirming the judgment and order of conviction passed by the trial court. And fifthly, the writ applicant herein dissatisfied with the order passed by the High Court dismissing his appeal referred to above came before this court by filling the application. It may not be out of the place to state at this stage that till this court dismissed the special leave petition with the order, the writ applicant herein had not raised the question of him being a juvenile on the date of the commission of the alleged offence. It appears that while the writ applicant was undergoing sentence of life imprisonment, he was subjected to medical examination by the medical board constituted by the respondent state in pursuance of the judgment rendered by a division bench of the Allahabad High Court in the criminal writ public interest litigation number 855 of 2012, wherein the division bench of the Allahabad High Court observed as admittedly as per the state's earlier affidavits, it was claimed that there were 72 prisoners who may have been below 18 years in age and who are detained in the various district or central jails. Prima facie, there appears to be some material for suggesting that such prisoners may have been below 18 years on the date of commission of the offences. After the modification of the Juvenile Justice, Care and Protection of Children Act 2000 by Act number 33 of 2006 under section 2(1) a juvenile in conflict with law means a juvenile who is alleged to have committed an offense and has not completed 18 years of age as on the date of commission of such offense under the provision to section 7a bracket 1 of the act. It is mentioned that a claim of juvenility may be raised before any court, and it shall be recognized at any stage even after the final disposal of the case, and such claim shall be determined in terms of the provisions contained in this act and the Juvenile Justice, Care and Protection of Children Rules 2007. We therefore direct the district judges, who are chairpersons of their respective legal services authorities, to directly oversee that efficient lawyers are appointed for the purpose of providing legal aid to the prisoners who have been mentioned in the list furnished by the state government and described to be below 18 years in age on the date of commission of offense. The said legal aid lawyers should get the ages of the prisoners ascertained by obtaining documents and carrying out the other measures provided under Rule 12 of the Juvenile Justice Act and rules, and also on the lines suggested by the Delhi High Court, Department of Women and Child Development, and other in its order dated 11th May 2012. The probable date of birth of other siblings can also be taken into account for ascertaining the true age of these prisoners. Stop. Starting in 5 seconds. The state of Rajasthan is in appeal before this court against the order passed by a division bench of Rajasthan High Court, Jaipur bench. By the impugned order, the division bench has upheld the order of the learned single judge, which had allowed the writ petition of the present respondent, quashing his dismissal from service. Respondent Phul Singh had entered Rajasthan Police Service as a constable in the year 1987. The same year, while he was posted at the police station Mania, district Dholpur, Rajasthan, he allegedly committed a criminal offence apart from an act of gross indiscipline. On the fateful day of 15th October 1987, he was wandering around the town in the evening in company of one lokman. Respondent was off duty but in police uniform when he allegedly caught one Mahesh Kumar and demanded rupees 100 from him. On his refusal, Mahesh Kumar was asked to show the papers of his motorcycle, and when he failed to show these papers, Phul Singh took hold of this bike motorcycle and then tried to run away with it. Meanwhile, due to The alarm raised by the Mahesh Kumar, a crowd also gathers in support of Mahesh Kumar. At this point, Fool Singh is alleged to have waved a gun towards the crowd but was nevertheless chased by the crowd till Fool Singh succeeds in getting inside his house, which was nearby. Once inside his house, he fires from his gun, which injures the inmates of the house, that is, his family members, besides damaging the property. All this results in lodging of an FIR against the respondent at police station Mania under section 392, 307 IPC and section 34 of Police Act. Read with section 325 of Arms Act. After investigation in the case, a charge sheet was filed against Fool Singh and Lokman. Ultimately, charges were framed under Section 392 IPC and Section 325 of the Arms Act by the trial court. The trial court then convicts Fool Singh under Section 392 IPC and Section 325 Arms Act and sentences him for 1 year rigorous imprisonment and fine for each of the above two offences with default stipulations. The co-accused Lokman is acquitted. This order was challenged by Fool Singh in appeal and sets aside the order of the trial court. Meanwhile, a departmental proceeding had also been initiated against the delinquent constable on 3 charges, which are as charge number 1 in the year 1987, when on 15th October 1987, U. Shri Fool Singh, constable number 386, was deputed with police station Mania at that time while off duty as guard. Time at around 3 p.m. dressed in police uniform, had consumed alcohol and under the influence of alcohol, being highly intoxicated, continued to roam around in Kasbah Mania and snatched away licensed rifle of Shivram Kachi. Charge number 2. On 15th October 1987, you, in a drunken state, dressed in uniform, along with Lokman Gujjar, went to Bedia Mohalla, where, being off duty and without any authority, you demanded for documents pertaining to Rajdoot motorcycle from Mahesh Kumar, son of Shri Hare, residents of Patpar Dholpur, and also indecently abused and demanded for a bribe of rupees 100 and forcibly looted and take away motorcycle from Mahesh Kumar, and due to which a lot of people gathered and they chased behind you. Charge number 3. On being chased by public, you ran and reached your quarter in the compound of police station Mania, and in a drunk state fired in your self-defense inside your house from the snatched away from Sivram, but the gunshot hit the balcony in the chalk of the quarter, and as a result, broken pieces of balcony fell on your family members, and due to which your family members got injured, and the sad incident led to the registration of FIR number 146 against you under section 392, 307, 34 of Police Act and 325 of Arms Act. Thereafter, investigation was conducted. In the departmental inquiry, 14 prosecution witnesses were examined. Some of these witnesses supported the case of the prosecution, others did not. Additionally, material exhibits were also examined, such as the first information report, the memorandum of seizure of the motorcycle, and more importantly, the breath alcohol analysis test of respondent, which was positive for alcohol consumption. The delinquent constable had also examined 9 defense witnesses. All the 3 charges were ultimately proved against the respondent in the disciplinary proceedings, and he was dismissed from service with order dated 18th December 1989. This order of the disciplinary authority was taken in appeal by a respondent, which was also dismissed by the appellate authority on 23rd August 1990. Then a review was also filed, which was also dismissed on 3rd June 1994. By the time the reviewing authority had dismissed the review of the respondent, who was also facing a criminal trial, was convicted by the trial court. Stop.